Welcome to Policy on Demand. I'm Wade Sutton. Tax controversy continues to be a major concern for companies, with new and varying challenges around the globe. Joining me to talk about what companies may want to consider are Nikole Flax and Laura Williams. Laura, Nikole, welcome.
Thanks.
So let's start maybe by setting the stage to talk about what cases taxpayers should be watching. Laura, maybe you could fill us in there.
Sure. Yeah, there are a couple of big cases that are in the Supreme Court right now. So Moore is a challenge, a constitutional challenge to Section 965. There were oral arguments at the end of 2023, so we're waiting to see how the court's going to come out there. So that's a big one that's of interest. Obviously 965, but could have broader implications into areas like Subpart F and guilty. Also, Loper v. Bright is one that people are watching very carefully. It's not a tax case, but it involves agency authority, right? Regulations, administration's ability to issue regulations, and could impact Chevron deference, which is a deference to the agency when it's writing regulations. So it could have a big impact for tax regulations. The third, I would say, is Liberty Global. That's one that's getting a lot of attention. It's a reg validity case where the taxpayer prevailed, but there was a kind of second piece to the case, which was the assertion of economic substance by the IRS and DOJ. And that's one that people are watching very carefully because we don't have a lot of case law around economic substance. So the company has appealed, but one to definitely keep an eye on.
So Nikole, with this changing landscape in the courts, how is the IRS reacting or changing its practices in the controversy space?
Yeah, so I think all the cases that Laura mentioned obviously are significant issues that have brought impact to a variety of big business taxpayers. And depending on the posture of the issue, the IRS is altering their approach. So obviously for economic substance, there is an actual decision that the agency views success in. And I think practically on that issue, a lot of taxpayers are feeling a lot of delay in their cases. The IRS is taking a look at economic substance. There are a number of transactions where they are determining internally if they're going to pursue it or not, and are attempting to take a strategic approach. And as part of that, Exam works very closely with counsel to ensure that they have an agency-wide view on some of these issues. And we're seeing a number of clients who are seeing just delays in moving through the system because of these issues that are out there, and the government trying to be strategic in how they're doing it. Obviously, with 965 and reg validity, they're in different maturities in terms of the issue and where they are. There are, a ton of reg validity cases that the government is working on, and just some interesting approaches that they've been taking. For example, we've started to see recently penalties being imposed on taxpayers who are challenging regs through refund claims, which is kind of a new thing that we hadn't seen much of, and have been working with clients to help them make the arguments against that, because it really is, the landscape is being developed, and the government is trying to respond one way, but taxpayers have a prerogative to push the issues that they feel strongly about as well. So it's evolving for sure.
Okay.
And the government is going to continue to defend their regulations, right? But we're also seeing a lot of alternative arguments being raised. So you may have a regulation that's right on point and the taxpayer is saying it's an invalid reg, and the government will obviously defend that reg, but also they're raising things like economic substance and step transaction, soft doctrines as well.
Yep.
So in light of all this, how should taxpayers be approaching controversy? What should they be thinking about? Laura, maybe we should start with you.
I mean, there's a lot of uncertainty right now, right? TCJA, all these provisions are still somewhat new. And so taxpayers have to consider whether it is in their best interest to settle, right? Or move on to appeals, perhaps get into litigation. There's a lot of uncertainty around that. So I think that's probably one of the most important things. And then obviously, looking for opportunities to kind of prevent controversy and get certainty up front to the extent that they can.
Yeah, just two things to weigh in on that. One, really understanding what the appeals landscape is right now, because litigation is obviously very resource intensive, and depending on the issue, there may be a high likelihood of success in appeals or not, and so that is an area of interest. And I think one impact of all the focus on controversy right now is it is impacting planning efforts in terms of when you come in from the front end, you can do a better job of ensuring you're not going to have an issue on the back end. So just ensuring, for example, business purposes documented, that you're aware of the things that the government is likely to raise, and that you have you have your documentation to support that going in.
Okay. And controversy is not just a U.S. issue. We're also seeing a lot of aggressive audits around the world. How are taxpayers responding to that, Nikole?
Sure. So I think a lot of it depends on what aggressive foreign jurisdiction it is, but there are a number of things that I think taxpayers are choosing of what their best path might be. So there's obviously the traditional competent authority programs that they can try to get relief through. The U.S. has been pushing ICAP as a way for transfer pricing issues to bring jurisdictions together, with the belief that as you have more at the table, it may drive more principled behavior, because you're trying to interact with a variety of jurisdictions. Have started seeing some taxpayers who are choosing or requesting that they actually get joint audits with other jurisdictions. They feel like having the U.S. at the table with the problematic jurisdiction might be helpful in terms of resolution. And then there are just business decisions that that taxpayers might make in terms of settling with a country because they feel like it makes sense business-wise. I think there we've started to see some issues that may have some legal impacts to the position that the U.S. is going to take with respect to those positions. So just to be mindful of kind of what the future might, the problems that you might have in the future in trying to defend that kind of approach.
Right. If you're settling with a foreign jurisdiction just to make it go away, you need to consider that what you're paying to that foreign jurisdiction may not be a creditable tax in the U.S., right? You may have a voluntary tax issue.
Right. Yeah.
Yeah. In addition to foreign law, we have this new global tax architecture that's being developed. Pillar 2 is being implemented around the globe. Pillar 1 is a little bit further behind, and the progress has been a little more difficult there. But do you anticipate that is going to reduce global tax controversy or be a source of global tax controversy?
So I don't think there's an expectation that it will, at least in the near term, reduce global tax controversy. I mean, clearly there is an infrastructure set up to try to deal with that, but I think there are a number of challenges to come, and I think there are just a number of questions of how that can all work effectively given the different landscapes that are out there, whether it's the heavy lift that will be required for some countries who don't have many resources, or just the behavior of other countries who have an incentive to act in a particular way.
Right. The international dispute resolution framework is there, but we'll need a lot of modifications to deal with the complexity of Pillar 2. I also think as countries adopt the rules and modify them, right, in their own terms, that is also, a potential source of controversy as different countries try to kind of, interpret in a modified kind of approach.
Yeah. And it's interesting to watch Pillar 1, because one of the premises of that deal was that we were going to get some amount B that was going to reduce transfer pricing disputes with certain jurisdictions. That's not looking very robust, and so I think that's another area where we're going to see continued controversy. All right, Nikole, Laura, thank you for joining us, and thank you for joining us on Policy on Demand. Take care.